Among your many judicial campaigns, Lord Denning, if I can so describe them, I think one that lawyers will always remember you for is the campaign that you waged, in the end victoriously, against what used to be called Crown privilege. Could you perhaps first of all explain what that was all about and how it affected the ordinary litigant in your court?
Well, the Crown claimed a prerogative. They claimed they needn't show a lot of the documents which they had in their own possession. They needn't show them to the other side. That's contrary to the ordinary rules, because they claimed a privilege not to. And this meant that if a litigant had a case, which he might well win if he could get a hold of the department documents, he would fail, because they said, oh, we have a prerogative to keep them secret. And, well, that came up from time to time in the old days. I don't know whether you'd like to know, but in the old days, if you had a claim against a government authority or indeed other people, and you wanted to see the policeman's notes and records, you couldn't see them. So as to win your case, you might lose for not having them. And that was the privilege which was claimed by the Crown to keep back documents in their own possession.
And wasn't this based on what they alleged was the public interest?
Yes, well, it came out in this way. There was a case during the war, in 1942, or rather just before the war, a submarine called the Thetis was sunk somewhere off Liverpool. And the question was, the dependents of the seamen who were drowned wanted to sue the builders, Cameron Laird, for negligence in the construction of the submarine. And the Crown said all the documents about the construction of this machine were secret, they were Crown privilege, and the complainant couldn't make out his case by reference to those documents at all. Well, that case came to the House of Lords. They held, I think quite rightly, that they were so special secrets, the construction of submarines, they couldn't be disclosed. But they went on to enunciate a very broad principle. They said that the departments had to keep their documents secret because otherwise people who were making reports wouldn't be candid. And there was a departmental blanket put upon all the departmental reports and documents which the departments had. And that was a statement by the whole House of Lords. There were 7 of them specially convened for it. In 1944, they laid down this blanket by which a litigant couldn't see the departmental documents. That's 1942. And it remained like that for a long time. A person couldn't make out his case. And we had a series of cases then coming in the Court of Appeal. Well, of course, I knew all about that rule, and I didn't like it much. I managed to get 2 Lord Justices of my line of thought. There was Lord Justice Harman and Lord Justice Salmon, and in case after case, we whittled down that. Because it only applied, you see, if the department or the minister gave a certificate claiming this privilege. And we hit down at these certificates with one after the other, and case after case. We managed to say something was wrong with the certificate, and the complainant could see the documents. I think there were 3 successive cases.
Weren't you known as the Three Musketeers in that period of the campaign?
Well, at all of us, yes, they took it right. Is it Dumas' book or whatever it is? At all of us, they said, these were the 3 Musketeers. They were me, Lord Justice Harman, and Lord Justice Salmon. But, you know, it came unstuck because there came up a case. I didn't know it was all going to concern this Crown privilege point at all. It was a case where a police cadet had been dismissed from the police force, and he wanted to see the superintendent who'd reported on him, and he wanted to see that superintendent's reports. He was suing for malicious for various things, but at all events, he wanted to see the reports, and then he was suing for what we call malicious prosecution, because the superintendent had said that this police cadet and another had been stealing a comrade's torches. And this police cadet had been charged before a jury. He'd been acquitted without being called upon, and he was suing this police superintendent for malicious prosecution. And the essential thing was to see the reports. Well, again, I didn't realize this was going to bring up a case of Crown privilege at all. And it came into a court differently constituted. I think it was Lord Justice Davis and Lord Justice Russell, and they wouldn't go with the Three Musketeers. They were quite the other way of thinking. Oh, they must go by the House of Lords in 1942, and the police cadet couldn't see these reports by the superintendent to make out his cadets at all. But there it was. I lost in this way. The other two said we must go by the House of Lords. I said, oh, well, I was going to dissent, and I did dissent. I thought he ought to see them. And I brought in quite a lot of cases from the Commonwealth, all on my way of thought. And so I dissented. And then it went to the House of Lords, and that was the great cases called Conway and Rimmer. And the House of Lords overruled that majority. They said that the police cadet and his advisors could see these reports of the superintendent of the police, could make out his case if he could with them. And they looked at the documents themselves, the Lords did. And they overruled this Crown privilege, and that was the turning point in the whole of this theory of Crown prerogative or Crown privilege.
Don't you think that's a good example of the fact that when you give unlimited power to somebody, a kind of blank check whereby they can the Crown used to be able to put in a claim of privilege for anything and everything, it naturally tends to abuse. And there grew up this idea that virtually every public document belonged to a class of documents which ought not to be disclosed in the public interest. But what was happening to the public interest in the due administration of justice?
Well, there is the real point which came out from those cases. The courts have to balance two interests. You see, the interests of justice required that the police cadet should see the reports upon him to make out his case. But they were saying that the public interest, not the administration of justice, but the public interest in the administration of the departments, meant that those reports had to be kept secret. And it was a question of balancing those two on the one side, the administration of justice to help the cadet, the administration of government departments to keep their documents secret and people make candid reports and the like. And in that particular case, if you balance those two interests, the administration of justice in favor of the cadet required them to be disclosed to him. The administration of departments didn't matter a bit in this. The interest of justice prevailed. But that's in subsequent cases. There have been many since that time. We've had to balance the two things. The interest of justice on the one hand, the interest of public administration, if I put it that way, public interest on the other side. And although it was fairly plain in that case of Conway and Rimmer, of the police cadet, it's been not nearly so plain in later cases which we've had.
And when it does this balancing act, the court, of course, has got to see the documents itself. In the old days, I think it couldn't even see the documents to see if there was any public interest in withholding them.
No, oh no, we didn't see them, couldn't have any means of gauging whether or not they were where the imbalance lay. But the House of Lords started looking at them, in that case I've told you about, and in later cases they have looked at them too. There was the big case of against the Burma company, you know. The shareholders were complaining that the Bank of England had been directed by the government to enter into and get all their assets at a very low price, and the whole question was whether or no the shareholders and those suing them could see the bank documents and could see the government documents. Again, it was a question of balancing the various interests, and eventually I thought the shareholders ought to be able to see them, if you ask me, but my others didn't agree, and the House of Lords didn't agree. They overruled me again, and they wouldn't let the shareholders see these documents, but only on this ground. They said the shareholders could get justice without, and the documents wouldn't add anything to the case. And they did look at them, as we'd done. They said the documents weren't really necessary, and so they wouldn't get them. So I was overruled in that one, but I wanted them to see the documents. But we've had even a much later case than that. One just before I retired. This is about Air Canada, you know. And a lot of the airlines wanted to sue the government and the Secretary of State because they said they were being overcharged at Heathrow for the landing charges, and that the Secretary of State had conducted himself improperly. He wasn't taking the proper things into account and all that sort of thing. And so there was an action brought by all the big airlines, including against the Secretary of State, saying he'd dealt with matters improperly. Again, we had the big argument. Again, the important thing was this minister, or rather in this case, the head of the civil service, made an affidavit claiming that the public interest, these were cabinet documents going up to the Prime Minister and discussed in cabinet and by the departments underneath them, whether they, the complainants, the airline, could see all those documents. Well, there was a special affidavit in which the head of the civil service, on behalf of the ministers, said that the public interest demanded that cabinet papers in particular should be kept secret. And we didn't overrule it. And the House of Lords affirmed it. You see, you have the other case where you have to balance the interests. We had the case where the NSPCC, which have reports from people who go and see whether children being maltreated or not. They go up through, it may be called informers and so on. They get information about treatment being maltreated. Well, some lady felt that the informer was altogether wrong. He'd been to her house and made a report on the way in which the child was being treated, and she was terribly upset about this, and she wanted to sue in that case the NSPCC and the others for wrong treatment, and she wanted to see the documents of information. Again, the public interest for the welfare of the child was that they should be kept confidential, rather than that she should see them in order to bring an action. It's always and be held that the NSPCC could keep their documents confidential. In every case, it's a question of balance the two interests. The private litigant or whoever is seeking justice, the interest in the administration of justice in the one pan of the scale, the public interest in keeping keys confidential and the other part of the sale and weighing them. It's very often a difficult balance, but that is the problem.
In that case you mentioned, which involved police informers, the House of Lords put up this new idea that it was a purely general matter of the public interest, which any citizen was entitled to raise, so that we had to learn to stop calling it Crown privilege and start calling it public interest immunity.
Yes, well, that's where they put it in a way. It's quite right. You balance the two interests. Where it was called Crown privilege before, it's called public interest now. But that doesn't go all the way, you know, because in that last case we had, the determining factor was the minister's certificate. And in the real Crown privilege cases, it's the certificate of the minister or the high officer which carries the day. In the other cases I've talked to you about, of confidence and so forth, there's no certificate of a government department at all, but you have a similar task. You have to keep the balance on the one side of the interest of justice in the particular case and the interest in keeping confidences in the other. Well, now, in all the cases about informers, of course, it's of the first importance to keep the name of the informer at all events secret, otherwise people wouldn't come forward. And so that's a case where the public interest is in keeping things secret or confidential. It's always a delicate balance between the two.
Do you think that information given in confidence or information given to journalists by their sources of information ought to enjoy special protection?
There's a very debatable point. Now take the case we had, and was there, where British Leyland were accused of discrimination between people of one colour and another. They were accused before one of the industrial tribunals, and accordingly one of the people who sued them saying he wanted to see not only the reports on himself as to how his conduct was, but the people who were up for promotion in the same sort of job who were white. And he said, I want to see not only the reports on me, I want to see the reports on everybody else. And university students could see the same. If they're rejected for a place at a university, they'd say, oh, I was rejected on the game of my colour. I want to see all the reports on the white people. I want to see them all too. In other words, they say, well, the interest of justice and discrimination, I ought to see not only reports on me, I ought to see all the reports on the white people. We said that would be going much too far. You can't see the reports which were given confidentially on other people. You can't see, oh, that's going much too far. And so it's again a question of holding the balance between the two. Where does the interest of justice lie? Or is it the interest of good administration or confidence on the other side? Newspapers too, you see. As you say, the journalists, the reporters, always say our sources of information are confidential. We can't disclose to you our sources of information. And the courts have said, well, yes, you must if it's absolutely necessary in the administration of justice. That's the thing. Is it absolutely necessary that the source should be disclosed? That we've had, of course, in other cases, such as the case of the mole and the British Steel and all that sort of thing. And it's again, in all those cases, it's a case of weighing where does the interest of justice lie on the interest of confidential information on the other side.
So now we've got a situation where the interest of the litigant at least gets fairly balanced up by the court, weighed in the balance against the public interest. Because, of course, in the old days it was so easy for a conscientious minister or civil servant to suppose that almost anything was better not disclosed to the public. Now we have all sides of the matter brought into account before the court. And here at least is one area where you were grateful for the support of the House of Lords. Of course, the question of journalists' sources of information opens up a large and very arguable field.
Yes, indeed.
Perhaps it's going a little outside our subject, but nevertheless, there's a balancing operation to be performed in that area too. Do you think that's analogous to the problems we've been talking about?
Oh, yes. Yes, indeed, because there's a balancing act there. I don't know whether I expect everyone remembers the British Steel and Grenada. You know what happened. Grenada managed to get hold of a lot of secret documents of British Steel, and they used them for the purpose of a television broadcast. And British Steel said, well, we want those documents back. And they sent the documents, but they cut off any means of getting the source of information. So the British Steel teamed against Grenada and said, we want to know who gave you these documents. There was said to be a mole in the whole question. And they claimed, the Grenada claimed they were sort of the journalist privilege not to disclose their sources. Well, there you had again the balancing act to be taken. British Steel said the interests of justice require we should be able to find out the name of this mole. And on the other hand, the journalists and the television people saying, no, it's the cardinal principle of reporting and journalists. We don't give our sources of information because the public interest requires us to give full information without disclosing our sources. So there you are, the balancing act again. It was a very, very fine line about that. And I can tell you that in the Court of Appeal I was very anxious about it. I wobbled first one way and the other. Eventually I went with my colleagues and I said they needn't disclose, they couldn't get they could get the name, and the House of Lords referred to that. But afterwards I changed my mind. And I referred to it in the latest book. I'm not sure at all that that was right. But that's a balancing act once more, and it's a very nice question. And I think the answer on that particular thing is that journalists ought not to be compelled to disclose their sources of information unless it's absolutely necessary in the interest of justice.